Chapter 4, the litigation process. Let's go through this and take a look at some of the things. I think, like I wrote in the note on the home page, it's something we all desire to stay away from, and yet will, in all likelihood, get drawn into at least at some point in our lives. But honestly, is it or should it be consuming? No. Typically for the normal person, it's not going to be consuming. It's going to be some of those things that you have to deal with. Hopefully you're on the right side of whatever those issues are. For example, not defending yourselves in a criminal case or something like that. So what do we got going on here? Well, as we say with so many things, having the rule of law that we have here in the United States and in other Western developed nations is absolutely essential. And having the ability to enforce things, be they criminal or civil, is once again just absolutely vital in order for us to enter into and have confidence that transactions or exchanges will take place as we presume. And honestly, 99.5% of all transactions occur without problems. And really the reason for that is the foundation that we have in our laws and the enforcement that would take place if the transactions didn't take place, as we presumed that they would. So we have to have this background, we have to have this setup, we have to have some experience of enforcement in these cases in order for things to proceed normally. And we just take for granted, every day when we go about our daily activities and the contracts and whatnot and the transactions that we enter into are going to take place as we expect, and they do for the most part. Litigation's what happens when something goes awry, right? We have plaintiffs and defendants. I know that in I see sometimes it's posted, and maybe this is just a local thing, but I think in divorce cases they list them as petitioner and respondent. I'm guessing that's to get away from this particular the labels, of plaintiff and defendant. There can be a counterclaim and a counterplaintiff, right? And it gets to be a little bit complex, and I wouldn't worry too much about it. And, certainly you need to know what a plaintiff and a defendant are. But you will see cases where one party sues another, and the second party that was the original defendant makes a counterclaim against the original plaintiff, and that's where those terms would come in, right? And then appellant versus appellee. So once we get past the stage of the original trial and it goes to appeal, again, we have those labels that we put on them. I think there I added there the petitioner versus the respondent, which I have seen in, like I said, divorce cases. And third-party defendants, I think that might have talked about that in your homework assignment, right? Where we're suing or somebody's being sued, but it doesn't necessarily incorporate all the parties to the action, and so a third-party defendant can be brought in. For example, if you bought an item from XYZ company and the item failed or caused some damage, you might certainly sue XYZ company, but if XYZ company was simply the retailer, they might want to bring in the manufacturer then of that item or the importer or whatever the case may be, to get a third party. So we have to have three things for sure to get into court, and one is standing. Standing means that we have to have an interest in the case, that we have to be involved in it. I think, and I should have looked, I think in Chapter 4, maybe it's in a different chapter, but it has the need now case, which I found, having lived through it, and I found it was really interesting that this fella had brought a lawsuit, Need Now had brought a lawsuit against the school system because his daughter was forced to say the Pledge of Allegiance, and the Pledge of Allegiance had the words "under God" in it, which he didn't like, and so therefore he decided to sue, and he sued, and the case went all the way to the Supreme Court, Okay, and it got there, and everybody waited with bated breath, wanting to know, if the Supreme Court was going to rule that either it was okay or not okay for students in public schools to say the Pledge of Allegiance with the words "under God" in it. And the Supreme Court punted. They came out, I don't know if they punted, but they just came out and said, hey, Mr. Neednow doesn't have standing. He is the father, certainly, but he was divorced from the mother, and the mother had primary custody. And she had no interest in suing, and so he pursued this, and it went all the way to the Supreme Court. They just ruled he didn't have standing, so they never really ruled on the issue of the saying the Pledge of Allegiance with the words "under God." It was really an interesting case, but I think it really points out, what standing is, right? That you have to have a personal stake in the controversy, or the court's not going to really listen to you. There's some exceptions when it comes to the press. And I'll give you an example maybe that's been going on. Judicial Watch, which is a nonprofit organization that kind of keeps tabs on the government, and they oftentimes sue the government over the Freedom of Information Act. Okay, they don't have a personal stake. The government hasn't been coming after them, to my knowledge, or anything, but there is reasons for our government to be transparent about these things, and they're seeking to ensure that happens. They're the ones that have brought forth the Clinton emails and lots of other stuff. Okay, and so that's called an overbreadth doctrine. I don't know that we get into that in this chapter, but yeah. So there also has to be subject matter jurisdiction, meaning that the court has to have jurisdiction in the subject matter. So if you tried to bring a certain case, a workers' comp case to regular court, the regular court might defer and say, nah, it's got to go through workers' comp here in the state of Montana anyhow. It's probably not in other states. Okay, and then personal jurisdiction means that is it the level of the crime. Okay, if it's a minor offense, maybe it should be in city court instead of district court. If it's a bigger offense, maybe it needs to be if it's a felony, for example, maybe it needs to be in district court. Or if the civil matter is for enough money, it probably needs to be in state district court versus the justice court or city court. Okay, and that's what personal jurisdiction might need, and you do have to have all three. Yeah, and I already talked about all of those, sorry. We do talk about long-arm statutes, and that is the ability to extradite, to go out and ask folks to come back, okay, or basically to defend themselves in that area, that geographic area. So standing to sue is allegations, right? You have to be involved, have to have personal stake. Okay, again, we talk about the adversarial relationship, and we've talked about that. Subject matter, does the court have authority? Again, depending on the level of the crime, the amounts involved, the diversity of citizenship, those types of things. And the diversity of citizenship in our state courts, might have an impact, right? If you get picked up, for speeding in Hill County, you're probably going to go to justice court, and that encompasses the county, and Liberty County probably has their own. But what happens if you're suing somebody who's in Cut Bank? Okay, which jurisdiction then, which state jurisdiction might have control over that case? Probably depends. In that case, it's probably going to depend on where the case was filed. Okay, and probably that jurisdiction would extend in those cases, depending again on the controversy. If you were suing over something that happened in Cut Bank, maybe an automobile accident or something, lawsuit then would have to take place probably in Cut Bank or Shelby or wherever their district court is. On the other hand, of course, if the accident or the crime or whatever the case that took place, happened in Hill County, might have to take place there, right? So there's some jurisdictional issues that can be like that. I suppose it might get confusing if maybe an elderly person was spending time between her two kids, and one lived in Billings and one lived in Missoula. and she died and there was a will contest. Where's that going to take place? Okay, those types of issues, I don't have an answer for that. Okay, those types of issues, the courts end up deciding that, depending again on where it was filed originally. General jurisdiction is the authority to hear any case, and that's, generally speaking, our state district courts have authority to hear a really broad range of cases, criminal, civil, just about anything, with the exception of some of those federal crimes, that we talk about. Limited is the authority to hear specific types of cases, and again, you got small claims. Okay, city court, which is going to, infractions that happen in the city that are misdemeanors, etc. Okay, and then we've got other types of courts, like in Montana, we have the water court and workers' comp court. Diversity of citizenship, I kind of talked about that in regards to state district, but it's true in federal district too for folks that live in differing states. Okay, again, can you sue Walmart in Montana? Sure. And, if you have a claim against Walmart because of something that happened here, even though Walmart's all over the world, you can bring the lawsuit here. And federal issues get decided in those cases. So, personal jurisdiction says voluntary submission to the court's power. Again, it depends on where you live, where you reside, and that is maybe more important for businesses, and where they do business. Okay. And the extent that they might do business in a certain area. The court has the right to summon people and force them or make them appear, okay, depending on the case. I don't know if any of you have ever been summoned, greetings. It's almost like the old draft notices from years ago. Greetings, the state sends you greetings. You're invited to come to this, and oh, by the way, don't miss it. It doesn't happen real often. We often we'd get summons at the bank for different cases that were going on, and sometimes I was the one that the guy would walk in and give you the summons, and you had to sign for it and la-da-da. Usually when it happened to us, we were expecting it. We'd already been told it was coming, and so sometimes they have to go through the official process. Long-arm statutes, again, courts have that ability to reach out, okay, and summon people from across that may have left. Somebody may have committed a traffic or been involved in a traffic accident, caused harm here in Havre, and then they take off to Wyoming. We can summon them and say, hey, you need to come back and face, the consequences here in Havre, okay, or if they committed a crime, whatever it was. Tort, again, that's the traffic accident. Maybe if they have property within the state, okay, or within a state district, okay, certainly they can be held accountable there. Or if a transaction occurred within the state, and that kind of gets back to Walmart. If you bought something here at the Walmart, you could certainly sue them here. Extradition is for that person that left and went to Wyoming. You can ask them to come back. The court can ask, that's a nice word, the court can say, you will come back. Class action lawsuits, and they get to be interesting. Companies do things, and sometimes they're odd and they're crazy, and so there's class action lawsuits that get filed against them. We read about some of the big ones. This is something you'll probably get involved in, or you'll get notices of periodically throughout your life. I suppose in my adult life, I've probably received direct notices of 6 or 8 maybe that we were involved in. The goofiest one, I'll give you a little story. Sorry, but my wife and I were at home, and we got a notice in the mail that we were a party to a class action lawsuit because we had stayed at a certain motel. They gave the name, and they were being sued because they hadn't properly disclosed some of the charges that we paid when we stayed there. And we thought, and we couldn't hardly remember having even stayed at this motel. It was one of those trips that you take where you're driving all day, and then you just look for a motel at night, and you sleep for 8 hours, and you get up and you go again. Well, that's what had happened, and we'd stayed at this place just the one night. So So we had to be a party to this class action lawsuit, for all the people that had stayed there, over a certain period of time, 6 months. Apparently, that's when fuel or energy prices were really high, and so they had tacked on an energy surcharge, and it amounted to a couple bucks. It really was virtually nothing. And so anyhow, we'd get notices as the case was going on, and of course it got settled, and so we received 2 coupons. It was interesting. Yeah, we got 2 coupons to save $2.50 per night if we stayed at one of their motels, and they were a small chain, I guess you could say, 6 or 8 different motels. And if we happened to stay at one of those again in the next 6 months, I think it was, we would save $2.50. The lawyers, meanwhile, if I remember reading the thing, I think they made $7 million or something off the case. So it was interesting to follow. Okay, and we've had some other ones that were kind of similar, where in the end they settled. The settlement amount, in terms of, from our standpoint as a plaintiff, ended up being little or nothing. So, do they have value? I mean, we'll hear a lot about how horrible those are, and how they pay big time fines, and the lawyers make a lot of money. But the other side of it is that some of these companies are doing things that are reprehensible. Will there be a class action lawsuit at Wells Fargo over the stuff that's happened? I mean, they just settled a fine. I don't think that's going to protect them from a class action lawsuit if, in fact, customers were harmed. Okay? I mean, they engaged in a behavior that was inappropriate and in all likelihood illegal. Okay? And so while I doubt that consumers, or if there are plaintiffs, will benefit a ton, Wells Fargo will get penalized, and maybe deservedly so. So it does kind of act as a good justice system, I guess, that we have, and so I'm a little bit in the middle, I guess, on some of these. Sometimes I think they're crazy, sometimes okay. Plaintiffs can pay the court costs. Obviously, if they get a settlement, those settlement proceeds would help to pay whatever those court costs might be. The settlement has to benefit the class and release all claims. Many of these get settled before they actually end up going to trial, right? So you'll get notice, and a trial's going to happen, on and on and on, and then you'll get a notice that they settled it. Okay. So procedural rules. Remember, we talk about substantive law versus procedural law. So we have the pleadings first, and that's the plaintiff, right? So the plaintiff files a claim, and there's an answer from the defendant, okay, or defendants, plaintiff or plaintiffs, and those are basically the pleadings. And then there'll be a bunch of pretrial motions. Both sides will probably move, or the defendant will probably move at least to have it dismissed, saying that the plaintiff doesn't have a case, and the judge will look at that. And every now and then that happens. I've seen that happen in criminal and civil cases, actually. There's other pretrial motions that occur, okay? And then, assuming those all get kind of settled, then we go through what's called the discovery process. And this discovery process kind of takes the excitement out of the trial to a certain extent. It means that we don't have the type of courtroom drama that we often see in the TV, the old Matlock or Ironsides, or Perry Mason. That was the old time one. Okay, so we don't have those courtroom dramas because a lot of this happens ahead of time. The parties get together, they dig for evidence, they do testimony, they do all kinds of things, okay, to try to ferret out all the issues that are going to take place at the trial. Okay. Then we have a pretrial conference, and that be in front of the judge, and they meet and they talk about it, and hey, have you guys settled? Or have you talked about settlement? Are you going to settle? On and on, and a lot of times settlements will occur somewhere between here and here. Okay. And then you go to trial if no settlement occurs. And trial is what you see, okay? You guys have kind of seen some of those or followed some of those in the news, certainly. After the trial, there'll always be a flurry of post-trial motions and sometimes appeal. Sometimes not, it just kind of depends. The defendant might say, yeah, it sucks, I lost, but it isn't worth it going through the appeal, and, they pay up, serve their time, whatever the case may be. Okay, but oftentimes there are appeals that will go forward. Yeah, I get ahead of myself a little bit. The pleadings, the complaint, and the answer, maybe some counterclaims. A default occurs, and it occurs when the defense doesn't really show up. We often won cases by default, and how did that happen? Well, somebody might have had a little car loan with us for $4,000, and we repossessed the car and got it back and sold it for $1,500, and so the person still owed us $2,500. And we could sue them. And so we'd sue them and take them to court. Well, they'd get summoned, and they would be told they need to show up in court, and oftentimes they just wouldn't show up. Okay, and so we would get a judgment by default, it was called, because the other party didn't show up. In fact, I think in small claims, things like that, I think I can only remember once or twice maybe where the defendant actually showed up. And I think the one time, at least in my memory, the judge basically said, well, did you sign the loan? Yeah. Do you still owe the money? Yeah. And that was kind of the end of it. I guess we got a judgment in that case. Basically, the person kind of pleaded guilty in a sense to not paying us back, and so boom, away we went. We never had any more than never had to go to trial or anything like that. Basically, the person just admitted to it. So there we go, pleadings. All right. Generally, the defendant's going to file a motion to dismiss. They probably keep those. They got them boilerplated, and they just give them. And what they say is the plaintiff hasn't made a case, that stands up. It's not prima facie. They can't prove it, on and on. And every now and then that's true. Every now and then I'll read in the newspaper where a judge has dismissed a case because, the plaintiff's, case just wasn't that strong, and so it happens. Sometimes some things will happen between when the plaintiff filed their complaint and the answer that the judge then would agree to dismiss. For any court to exercise authority in any given case, which the following must happen, let's say all of the above, how about? Yes. So again, we got discovery in lawsuit or criminal case, right, is based on the merits of the case. It really assists in trial preparation. It does try to narrow the issues. Some of the methods, and I think, again, this was your guys' maybe assignment, but you can have interrogatories, and that's just questions that one side asks the other. Okay, it's just a series of questions, and the other side has to. They're compelled to answer, and I believe those answers are under oath. Okay, request for production of documents. If it was a suit for wrongful discharge or something like that, you get the person's file, personnel file, those types of things. Depositions, they're kind of interesting. I've had to sit through a few of those where you show up and with your attorney and the other side and their attorney and the little court reporter person, and you ask questions back and forth. And the thing that's interesting about depositions is that there's fewer limits on the questions that can be asked, and while the judge may rule that some of that stuff's inadmissible in court, okay, in depositions they kind of get free rein to ask them, and then the judge makes those decisions kind of later. And then there's request for admissions, and that's request for admission of evidence that might exist, right? That's kind of what I was talking about, that there's a ton of stuff that gets found out in discovery, but there's certain parts that may not be admissible in the trial itself. If the person's personal life has no bearing on the case, they might still ask questions at the deposition. Do you drink a lot? Do you smoke a lot? Do you do drugs? And those things may not have a bearing on the case, and so the judge may rule that they're not allowed. Discovery can be expensive, time-consuming, on and on, but it settles and ends up settling a lot of these things prior to court, prior to actual trials. Oftentimes in the discovery process, the sides will come together and come up with some kind of a settlement because they kind of see where they're standing. They kind of get a feel for how the court or how a jury might respond to the case. Parties can become aggressive. The few that I was involved in, I would say there was never any aggression. damage to the litigation process, yeah, maybe. I would think that most attorneys and most judges would argue no, that it's a big plus for the litigation process. You got to act, of course, reasonably and prudently and avoid some extreme positions. Motions are, on questions of law, like a statute of limitations. Is this case beyond the statute of limitations? A judgment on pleadings or a summary judgment, meaning that, the case has been filed, the complaint has been filed, and the answer has been filed. And oftentimes a party or parties will ask the judge to rule on summary judgment, saying, the evidence here is so overwhelming that, why go to trial? Why not just rule in our favor, based on the evidence that you have before you? And I've seen, in fact, we were in one case, at least one, probably others, where we were awarded summary judgment by the judge in the case. It was interesting, though. That case, the one that I'm thinking of, that case is also the only one I know of that ended up going all the way to the Ninth Circuit Court. The party, in this case it was the plaintiff, took it all the way to the Ninth Circuit Court and lost at every level. Still cost us just a boatload of money. Affidavits are simply statements by parties involved. Okay. Again, I believe they're under oath. And frivolous cases, so sometimes they get kicked out. It'll be a motion that asks the judge to kick out a case because it's frivolous. I remember being involved in one of those at the bank, and we were successful. Somebody was suing us for bad faith, and we asked the judge to throw it out because it was frivolous. The judge not only agreed with us, but also censored the attorney for the plaintiff in that case, saying that, don't be stupid anymore. Another good quote by Thomas Jefferson, no shortage of those. So Vardar, or however you pronounce that, right, is to speak the truth, and it's about jury selection. I'm right in the middle of a John Grisham novel, actually getting towards the end of it. What's this one called? Sycamore Roll. And they're right in this process right now of selecting the jury, and it's really kind of interesting because it is these things that we talk about, right? Challenges for cause. If you know one of the parties involved, that would be a cause to have you eliminated. If you know one of the attorneys, maybe you're friendly with one of the attorneys, that would be cause to have you eliminated. In a criminal case, maybe you're good friends with either the defendant, or maybe you're good friends with the police officer that made the arrest, or those types of things, right? And so for cause is, you get thrown off. Peremptory means that each side is oftentimes granted a certain number of challenges, I guess they call it, where they can just ask people, not ask them, they can have people eliminated from the jury pool. Okay, and they might get 4, they might get 6. It kind of depends. Every jurisdiction's different. Okay, and cases are different. Criminal maybe versus civil, and so the sides will pick out of the first X number of jurors. Okay, and jurors are picked at random, and they show up, and then they're kind of numbered. Basically, if you're number 1 and you don't get kicked off, you're probably you're gonna serve then, right? Presume you're going to have some getting kicked off and whatnot. So a 12-person jury, they might want to bring in 25 or 30 people to be in the jury pool, because a certain number will get kicked off, and each side will get to use their peremptory challenges, and boom, then you get down to the 12 that are then they're seated, and oftentimes there's a couple of alternates too, depending on, again, the complexity of the case. Okay. They talk about elimination of maybe peremptory challenges in some cases, and I think the book gives you a few good examples that in some cases, they can be used to, for example, in one case I think it gives you, they eliminated all the men on the jury. They had enough peremptory challenges, and in the remaining jury pool, they were basically able to eliminate all the men. And you had an all-woman jury, and they deemed that ended up being kind of discriminatory. Okay, I think it went to the Supreme Court, and so there's talk about maybe eliminating those. Certainly, you could reduce them, and that might help solve some of the problem. But as it stands right now, it still exists. It's still the way, one of the ways that we deal with picking a jury. So, and here's some examples here, right? 86 was racial. That's not that long ago. That's just amazing, really. 30 years ago, right? And then in 94, yeah, not all that long ago, the gender discrimination. Right? So now we have the trial. We get jury selection, which we just talked about. Then we have opening statements, presentation of evidence. And then we're going to have another motion asking the judge to make a verdict because one side didn't really present a powerful enough case, and there's no sense going through the rest of it. Probably doesn't happen very often at all, maybe occasionally. Closing arguments, instructions to the jury, and then ultimately a jury verdict, a lot like what we do see. So the burden of responsibility or evidence, and here we need to really make a distinction between criminal and civil, right? A criminal case is beyond a reasonable doubt. What that means really is a unanimous jury. Okay, so a jury has to decide unanimously if somebody's guilty or innocent. Okay? That's a pretty high standard then to find. And you'll see sometimes when they'll call it a mistrial, but they call it a hung jury. Well, that's a jury that just can't get past that. 12 people in the jury, and maybe it's 9-3. Maybe it's 8-4. Whatever it is, they can't get past that. They can't convince the other 4 of the minority. They just simply won't change their minds, okay, regardless of the arguments or whatnot. And then you have a hung jury, and they call that a mistrial. And when that happens, okay, then the plaintiff, whether that's the state or whether that's somebody suing the other, has to decide whether or not they want to pursue it. Now this is on the criminal case, so it would only be, it's not lawsuits, this would only be criminal. Okay, so the state really has to decide whether or not they want to pursue another trial. Okay, and try again, maybe to convict that person, and sometimes they'll do it too. I've seen sometimes go through a couple of trials and still end up with hung juries. So the evidence isn't maybe overwhelming in those cases, but it has to be beyond a reasonable doubt, which again is a unanimous decision. A civil case is a preponderance of evidence or clear and convincing proof. Now, and this means that it might be a majority or supermajority. And there again, that probably depends on the jurisdiction. Those probably change from jurisdiction to jurisdiction. So, I'm not going to ask you a specific question about what that means, but it doesn't mean that it has to be unanimous. So it could be 9-3, for example, might be sufficient, or 8-4 might be sufficient then to carry the day in that type of a case. Okay, so the case is all done, and the jury decides, and then ultimately the judge still has to say, okay, we're going to enter a decision based on the jury's decision, la-da-da. So it's really the judge that finally says, okay, what the verdict was. But the judge can also say, well, and this doesn't happen very often, but I've seen it in the news maybe once, okay, maybe twice, where the judge says, I think the jury screwed up. I listened to the same thing, and I just can't believe they came to that kind of a decision. I think they're nuts, or they were swayed by something, Maybe they were swayed by a good-looking lawyer, and, they didn't really come to the right decision. And a judge can overrule, basically, a jury's verdict, okay? And that would be a judgment notwithstanding the verdict, okay? And I think they give it another name if it's in federal court. But, again, it's very rare, but it does happen. Okay, then we can have an appeals process, and like I said, you'll often see appeals. Briefs are filed. Oral arguments might be made if the appellate court agrees to hear the case. Okay, if they don't agree to hear it, then it's over. Okay? And there'll be a judge or justices or a panel's opinion, okay, of the appeal. Typically, they defer to the trial courts. Okay, enforcement, and this isn't. This would be for civil cases, where you could execute in order to in order to recoup your losses, or you can garnish, which is garnishing somebody's wages. A lot of these cases against big companies and whatnot, obviously, they're going to write checks, and it's not too difficult to get paid. But against individuals, maybe that owe you some money, it can be a lot more difficult, right? So you might win a judgment against Joe Blow that wrecked your car and didn't have insurance for $5,000, and the court says, hey, you win. Sorry, but your work's not done. The court doesn't, in that case, they don't become the collection agency for you. Yeah, you have a judgment, and the other party owes you the money, but now you've got the arduous task oftentimes of having to collect, and that can really be a pain. The doctrine of res judica means that it's over. Judicata, I think, is how that's pronounced. So just means that it's over, it's done. So if a decision is made at the trial court level and an appeals court refuses to hear it, it's done. Okay. A directed verdict refers to, let's see. There you go. Let's go with the number D, or letter D, on that. Power of a court to grant a decision in favor of a defendant when insufficient evidence is presented at trial. What's class action lawsuit? We talked about that. How do depositions operate? I kind of gave you the quick version of that. They are interesting. You could be in depositions for a long period of time. The few, I guess, that I was in, a couple hours maybe, 2, 3, 4 hours, and just, yeah, kind of a pain. Kind of seemingly a waste of time. But can you decline to testify at a deposition? Yeah, you kind of can. Okay, but you can be compelled. But if you're compelled, I think then they have to pay you and do some different things. Okay, I don't think I asked that on the test. There you go, Chapter 4.